get your property when you die? You can decide that by naming beneficiaries in your will. A beneficiary can be a person or an entity such as a charity. Most people choose their family members or loved ones, but a beneficiary can also be an organization or a charity that is close to your heart. They will receive your assets such as real estate or personal property, for example, your jewelry or your car. If you are married, you will most likely name your spouse as the main beneficiary in your will. Your spouse can receive all of your estate or part of it. However, your state will have specific laws that set the minimum share your spouse is entitled to receive. These laws make it quite difficult to completely disinherit your spouse. And there is a further consideration that depends on whether you live in a common law state or a community property state. There are 41 common law and 9 community property states. Under common law, the spouse is protected by laws that keep them from being left out of your will. If your will leaves him or her with a share smaller than the law allows, your spouse can contest the will. In the 9 community property states, Arizona, California, Idaho, Louisiana, Nevada, New Mexico, Texas, Washington, and Wisconsin, the spouse is protected differently. The law allows you to leave as much or as little as you wish because the law recognizes that these spouses share your earnings throughout the marriage. Who are your other beneficiaries? Most likely your children will be next in your planning after your spouse. If they are adults, you will decide whether or not they get equal shares or not. You can also specify particular pieces of your property to go to particular children. If they are minors under the age of 18, you can still leave things to them and put restrictions on them gaining access until they are of age. We will talk more about bequests to minors in our next video. But unlike spouses, children do not have the same legal protections under the law that enable them to receive a certain share of your estate. This means you can choose to completely disinherit a child and keep them from receiving any of your property under your will. Some people name friends, stepchildren, or other relatives as beneficiaries as well. You can even name a charity or some other non-person entity. It's important to be specific in naming these types of beneficiaries, giving contact information where possible. This will make it easier on your executor to make the distribution. For purposes of a last will and testament, your children refers to any children born to you, including those from a prior marriage or legally adopted by you. Stepchildren generally are not considered your children by law unless you have legally adopted them. However, there is no restriction on who you can leave your property to, and you are free to leave your property to children and stepchildren in your last will. One final point about beneficiaries is the importance of naming an alternate or contingent beneficiaries. If the person named dies first, rejects, or cannot receive the gift and no alternate is named, it is as if no one was named. The property goes into your general estate. Naming a contingent beneficiary has another advantage too. If the primary beneficiary doesn't want the asset for some reason, perhaps because of tax implications, he or she can waive rights to it, allowing the money to pass to the contingent beneficiary. Many surviving spouses do this for their children, and it can be a smart way to avoid or reduce taxes. But if you fail to name a contingent beneficiary, this opportunity is lost. So spend some time thinking about who you want to inherit your estate. It can save your loved ones some aggravation, confusion, and even a few headaches. In our next video, we will take a closer look at some of the finer details with making distributions in your will. Stay tuned.